Danny Sheehan, as you know, co-founder of Romero Institute, beloved constitutional attorney who has been involved with the key issues our entire lifetimes. I'm 75. Our birthdays are about a month apart. And so every time there's been really something important in our nation, Danny has been there as the constitutional attorney of record. So, Danny, can you take us? You're going to update us briefly on Lakota issues and on California Green New Deal, and then dive into Constitution and COVID and whatever else you want to share with us at this time. Thank you. Danny Sheehan.
The first thing on our agenda is the Dakota Access Pipeline. As you know, we've all spent an awful lot of time since the middle, basically June of 2016, all the way up now on the brink of June of 2020. For 4 years, we've been engaged in that struggle. And just recently, on March 25th, the federal judge in the case in Washington, D.C., that had been filed by the Lakota people to try to stop the pipeline, has finally relented and acknowledged that the pipeline was unlawful and that the permit never should have been granted. That was a huge victory. So you would think on the face of it that it would require an immediate ruling on his part, shutting off the oil from the pipeline and ordering it out of there. But he hasn't done that. Judge Boasberg, who's the federal judge there in Washington, D.C., has asked for briefs on that. He's basically putting the burden on the plaintiffs, which is Earth Justice, on behalf of the Lakota people, to convince him that he has to shut off the oil during the pendency of this 1 year or more that it's going to take to complete this environmental impact study. And very importantly, those briefs are due on the 20th of this month, just basically a week from now. And we have been invited, the Lakota People's Law Office have been invited to provide what they call amicus brief. And we're going to be addressing a very specific issue that is why the court must, as a matter of constitutional law, as a matter of the due process of law, terminate the flow of the oil through this pipeline during the pendency of the environmental impact study that's now been ordered by the court. Now, in addition to that, the Keystone XL pipeline, the tar sands pipeline, that is on the whole western edge of the Dakota Territory. The federal judge up in Montana has issued an injunction, a second injunction, in fact, declaring that all work on the pipeline and all ancillary structures, such as the man camps, the clearing of the brush, the digging of the pipeline channel, everything has to stop right now because the United States Army Corps of Engineers had failed to comply with the requirements of the Endangered Species Act, did not in any way consult with the National Wildlife Associations to try to determine what the impact would be on the wildlife in the area. He had previously struck down the pipeline permit on the grounds that it violated the National Environmental Protection Act. So both pipelines are now under federal judicial orders to declare them illegal, and the process is underway right now, which is going to be going on during all this next week to get them to stop all construction on both of those pipelines so that they're terminated right now. Okay, so that's all extraordinarily good news. And the third item of just an update on this is that we're still very much underway in preparing the draft of the California Green New Deal. We are in the process right now. We've been reaching out to some 100 different organizations around the state and around the country to check out the technological viability of various portions of the statute that we've drafted, and we're testing the constitutionality of these rules. We're not in the habit in the progressive community of exercising state power, but to the extent to which we're drafting an actual statute that's going to be passed by the state Senate and the Assembly, we have to be careful that the power that is being asserted through the legislature is within its constitutional limits. So that's going on right now. And I want to spend the additional time that I have to discuss this issue of the constitutional issues that are involved with the coronavirus pandemic. We talked the last time we were together about this extraordinary assertion that has been being made by Donald Trump and his Justice Department under William Barr, that Trump is authorized basically to do absolutely anything he wants in the event of an emergency like this, and that he has so-called secret powers that are all part of a series of, as it turns out, executive department unilaterally issued edicts, which they've garnered unto themselves the ostensible authority to do whatever it is they feel like doing. We discussed that the last time we were here. I discussed some of the historical Supreme Court cases that have visited this issue, pointing out that there is some danger in this area for us, and we addressed that. What I want to talk about tonight when we're together is trying to deal with the fact that there has arisen a great deal of confusion in the face of this coronavirus pandemic. There's a lot of people are extremely upset about being ordered by the state. And when I use the state, the power of the state, that covers both federal government and state government. The exercise of power by any government agency under our Constitution is limited. And here we find ourselves faced as citizens with these orders that are coming down from either the state or the federal government, ordering us all to have to stay in our homes, ordering us not to go out of our homes unless it's for necessary travel, to go to the pharmacy for prescriptions or to the stores for food and supplies, and potential repercussions if you don't do that. And now we're faced with differing orders across the country of different governors opening up certain portions of their states. Some are going to be opening up their beaches. Others are opening up everything, including tattoo parlors and massage parlors. And there's all this hodgepodge of rules and regulations going on. In the meantime, we're still facing lots of confusion about whether or not there are adequate testing kits and testing means available to determine whether people really have the virus or not, what type of death rates there are in relationship to the number of actual cases there are. And we realize that some of the tests that they have now are generating lots of false positives and false negatives. And so there's a lot of questions now about what authority the federal government has or what degree of responsibility it has to actually develop a test that is completely reliable. And there's all kinds of concerns that are being raised now about the ostensible need to track anybody's movements, anybody who is diagnosed with the coronavirus right now, tracking all of their previous movements over the last 2 or 3 weeks prior to being confirmed as a carrier of the virus, and that they're getting access to their telephones. They're reaching out to the telephone companies, the cell phone companies, to get a record of all of the places you've been. As it turns out now, these cell phone companies have a complete running record of what cell phone tower you used to make a call on your cell phone, so they can locate where you were. They are now looking into trying to determine how many other people you came into contact with by tracing other people's phones. This raises a huge set of fundamental constitutional issues about your rights of privacy, the partnerships that are being established between these ostensible private companies like Facebook and Google, and the telephone companies, the different services that they have, them succumbing to state demands for information that they're gathering. That they had been gathering this information ostensibly just to sell to commercial organizations that wanted to know where you went during times to figure out what kind of ads to try to sell to you. And now the government is getting access to this information, which begins to infuse a lot of these activities on the part of erstwhile private companies such as Facebook and Google, et cetera, with certain indicia of state power now. And so there's all these issues that are arising, and some people, as we know, have actually begun to question the legitimacy of the death rates that are being cited. They're convinced that a lot more people are being designated as having died of the coronavirus than really did. There's all kinds of other people that don't trust the statistics on what the rate of contagion is for this. There are all kinds of people that are upset, that believe that the restrictions that have been imposed upon us are overbroad. There are all kinds of regions that have virtually no cases of the coronavirus, and they're still subject to the same limitations of travel and social contact, and that they're upset about this. And some people have actually gone so far as coming to suspect that this whole thing is a hoax of some sort, that in fact, all of the statistics are being vastly overstated, and that there's some kind of grand conspiracy going on to try to just train everybody up to be submissive to government instructions. And so that this situation has generated a division. We've touched on this in the past, where people who are on the extreme right wing of the political spectrum believe one whole set of facts, and the people who are on the left edge of the political spectrum, progressives and liberals and utopianists, all believe an entirely different set of facts about this, and have completely different levels of trust in the government. And yet what we see happening now is that the two camps, the Reds camp and the blue camp, are all listening to only their own media. The people that are in the blue states, they're the Democratic Party dominated, are listening to MSNBC and CNN, and they're reading the New York Times and Washington Post, et cetera. And the people in the red states that are dominated by the Republican Party are listening to Fox News and reading the Wall Street Journal. And they have a whole different take on what's going on. And each of the people in each of the camps believes that all the people in the other camp are being propagandized by the sources of information they're getting. So all the people in the red states think that the people in the Democratic Party are being duped by CNN and MSNBC and all the people that are in favor of kind of one world government, and all the people that are in the blue camp believe that all the people in the red camp are being completely lied to consistently by Fox News and by the Trump administration. And so that we have a situation here where the country, the division that has arisen in the country prior to the onset of this particular virus is being exacerbated. We had a situation in the country that had led all the way to the impeachment of President Trump, and that people had 4, 5, 6 different grounds on which they thought he should be impeached. And he ended up getting impeached on this almost a completely different one, all having to do with this phone call to the president of the Ukraine, and it convinced the people on the right that the Democrats were just looking for anything they could think of to try to get this guy impeached. And when they failed to succeed in getting him impeached because of the investigation of Mueller on the collusion between the Trump campaign and Russia in the presidential campaign in 2016, that they just went after something else. So that this distrust on the part of the people in our country for each other on the left and the right of the political spectrum has been exacerbated considerably by this coronavirus. And the perceptions that people have of all the different factual data that's flying around is completely colored by the two prisms that people are looking through. What I want to do here today is I want to be able to point out now that there is a juridical, legal mode of reasoning that has been developed by the American judicial system, which is usually used to evaluate a government action, either a state or federal government action, which appears to be discriminatory toward a particular specially protected group is subjected to this, what they call strict scrutiny. And the constitutional scholars will make an argument here in response to what I'm saying is, no, this is only applicable in equal protection context. But the fact of the matter is the principles that are available under this analysis are available to us now. And I want to lay it out to us so that all of you are familiar with these tools so you can talk with your friends who say things that you don't agree with or say things you do agree with to some kind of strict scrutiny here. And so here's what the strict scrutiny test is traditionally, is that if in fact a state government, legislature, or executive branch issues an order or an edict, let's refer to a piece of legislation, and it is seen to have a disparate impact, adverse impact on a specially protected group, say Black people, for example, who are historically discriminated against. And so there is this intrinsic suspicion with regard to any type of state law that has a discriminatory impact upon Black people because of the horrible history of our country in discriminating against Black people based on their race, that such a law has to be subject to strict scrutiny, and that there is a 3-level test, and some people say a 4-level test that statute has to be subjected to in order to survive a constitutional challenge. And what I'm saying is that we can apply this in our present situation without it having to be restricted to a violation of the equal protection of the law. We can use this particular standard test to determine whether a statute is constitutional at all. And so therefore, the first question that we would have to ask about any of these rules and regulations, was there a compelling government interest that motivated the enactment of this law or the issuance of this order? Not just a vague legitimate government interest of all the different things that governments might want to be interested in doing, but was there a compelling government interest in doing this? And what this does is this first step in the strict scrutiny test, what this does is it provides a basket into which you can throw all these questions about the legitimacy of what it is the government is doing. Was there a compelling, legitimate government interest in issuing these rules? And so you'd say, look, this is where if you don't think that there is a real pandemic, you don't think that this virus is any more serious than the normal flu, that doesn't generate rules like this. Anybody who believes that any of those rules or regulations fail to have a legitimate, compelling government interest can undertake this type of analysis. The second test is this: does the enforcement of this particular rule significantly infringe upon the exercise of any fundamentally protected right? And this is an important element. And usually, the test is in this thing is, does it discriminatorily impose a greater restriction on a specially protected group, like the Black people, the Latino people, Asian people, people who are like socialists or something that are historically discriminated against? You know, is there some sort of discriminatory element to this statute? I'm setting that aside. I'm not going to insist we have that here. So the fundamental question here translates to, does this law, assuming that you can show there's some legitimate government purpose or even a compelling government purpose for it, does it significantly infringe upon some fundamental right that we have? Right to free speech, right to freedom of religion, right to go to church that you want, right to gather publicly, the right to gather in publicly protest. The whole panoply of things. For example, your right to get access to the internet and challenge the bona fides of the pandemic. To say nothing about this fundamental issue, if they're going to issue an edict that you have to be vaccinated, there's this profound fundamental Fourth Amendment right as to whether or not the sanctity of your own body can be violated by a mandate from the state to insist that you subject yourself to a vaccination. Or they're going to start restricting you from being able to go out in public, prohibit you from going to school. If your kids don't get vaccinated, they're going to deprive them of a public school education. There's all kinds of fundamental rights that are clearly at issue here. And this is the factor that is causing such a strange alliance to be formed between normally extremely right-wing people and very progressive people who are all extremely sensitive about the over-assertion of state power infringing upon our fundamental rights. We all share a high level of sensitivity about our fundamental individual rights being violated by state action. And so that under this test, there's a whole basket to be able to put all of these violations into to make it absolutely clear that our fundamental rights are being infringed upon in substantial ways by these rules and edicts that are being set forth. And so the third question, the third step of this strict scrutiny test is that if in fact you found that there is a compelling government interest, a compelling legitimate government interest in promulgating these rules, and you find that they do in fact generate significant infringement on our fundamental rights, the third question to be asked here is the law narrowly crafted enough to not infringe upon our fundamental rights to any degree more than which is absolutely necessary in order to effectuate the legitimate government interest that was put forth to justify the enactment of the statute. Now, this is that whole question of overbreadth. Is the government lazy and it's just sort of through the legislature has thrown out a whole big broad restriction on all kinds of activities that you're engaged in, that many of which are not even necessary in order to carry into effect whatever the legitimate purpose of the statute was, to keep you from infecting other people. So, for example, a person that gets arrested for being out on a river, in their own canoe, just canoeing along all by themselves, miles away from everybody else. Is it legitimate to arrest them for violating the stay-at-home rule? Even if they're not going somewhere that's absolutely necessary. So that this third stage of the strict scrutiny test is extremely important, because what you want to do is, even if there's a legitimate government reason, even a compelling government reason for enacting one of these rules, can it in fact be narrowed much more so that it doesn't restrict our fundamental rights to any degree, one single degree more than is absolutely essential in order to carry into effect the legitimate interest that the government had in passing the rule. Okay, so that's an extraordinarily important stage of this thing, because then what it can do is it can order, and it can do one of two things. It can either order that the law be enforced in a way that is extremely restricted, only to those actions that are absolutely necessary, or they could in fact strike it down entirely. To strike down the statute on its face, okay, if they chose to. But so this brings us to the fourth test. And this is one that many scholars don't impose this one, some do. And that is the fourth test of the strict scrutiny test. Even if you assume that there was a compelling government interest in promulgating the law, even if in fact you realize that it does infringe upon fundamental rights, and even if you see that the law can be restricted to a very narrow scope, so that it only infringes our fundamental rights to the degree that's absolutely necessary in order to carry into effect the government compelling interest that they have. The fourth question is there any evidence that there was an ulterior motive on the part of government officials in promulgating this rule? Now, usually, as I said, in the equal protection context, was there some sort of bias on behalf of the legislators, even though they've come up with some rationale of a legitimate government reason for doing it, that there's really some evidence of an ulterior motive that they were really attempting to discriminate against and historically discriminated against group. The way that would be applied in our case is there any evidence of any ulterior motive that is not the same thing as the legitimate government interest that they publicly profess to have been the motive for the statute? And this is a basket that is very important now in all of these conspiracy theories that are flying around. Because if people believe that there's some legitimate conspiracy going on here, or some illegitimate conspiracy going on, this is where you would have the opportunity to put the questions into this basket, this fourth basket that you have, this fourth hurdle that has to be overcome for a statute to survive the strict scrutiny that we're bringing to it. And that is, for example, some people assert that there's a big conspiracy on the part of big pharma to make everybody have to get vaccinated because they own the patent on the vaccination, and they're going to make billions of dollars. And so that they've got this craven financial motive for lobbying to get the legislators to pass this law, and then they're going to give more money to the legislators that agree with them for campaign contributions, under the Citizens United case. That there's all kinds of ways you can figure out if you distrust government as much as you should. There's all kinds of conspiracies that people can see. We should not take steps to suppress people who are asking those questions, who are even hypothesizing that those things are true. You should not shut them off from the internet. You should not shut them up. What you ought to do is provide a means by which they can test those hypotheses, or you can challenge those hypotheses. So you put all of those different theories into this fourth basket and say, okay, if you want to put up, you don't have to put up or shut up, but just put it up. Put your evidence up there and put it in a coherent form so that people can take evidence on it. So people can be deposed, people can be subpoenaed, records can be subpoenaed if you think they exist to support that. We have a device that's available to us through the legal procedures. If anyone wants to file a federal civil rights action against any one of these orders or any order or statute that's been passed, you can file a federal civil rights lawsuit against it and invoke the strict scrutiny rule and start to demand that the government be required to prove its compelling government interest, prove that what they're saying about the coronavirus is true, subpoena their internal records to find out what the discussions were that were going on there. We don't have any trouble showing that all kinds of fundamental rights are being infringed by these rules and regulations. So there's no real problem with the second step of this test, that it's substantially infringing upon fundamental rights that we have. And that the question about whether they're narrowly tailored, you see, for example, that you saw the mayor of one of the towns down in Orange County going on statewide television accusing Governor Gavin Newsom of discriminatorily shutting down the beaches in Orange County because the people in Orange County are basically Republicans. And so therefore he's discriminated against them by closing their beaches and allowing other beaches to remain open. And so you get a classic example here where they should file a federal lawsuit. They should file a federal lawsuit against that. And if they think that there's evidence that he was doing this specifically to discriminate against Republicans, then they get access to the internal records of the administration and how they went about promulgating this particular rule, ordering the closing down of the beaches in Orange County. And others, if they believe that the law is not adequately narrowly tailored, what they ought to do is they file a lawsuit against this, arguing that the rules that have been promulgated are overbroad. I'm a great fan of government agencies being litigated against. There ought to be full-time public interest lawyers around litigating against government agencies that promulgate rules and regulations that are shown to restrict the freest possible exercise of our individual liberties. I mean, sue the shit out of them, every minute you can. I mean, that's what we're trained to be doing. The constitutional scholars are trained from the first course they ever take in constitutional law, distrust government agencies. Distrust government. And that's where we share. The progressives and reactionaries and libertarians and everybody all share that same type of sensitivity. The people that end up losing that sensitivity as citizens are people who get working for the government. And they get working for law enforcement and the government, and then all of a sudden they lose all of their sympathy for constitutional rights because they see how hard their job is. They don't want to have to spend all the extra time of being extra careful about people's fundamental rights, and they want to be able to just promulgate whatever rule they happen to think they want to do. And so that the people who are employed by the state or federal governments, no matter how much you like them, and I'm including state legislators, and I impose those restrictions on us in crafting the Green New Deal, that you aren't going to find a tougher customer than me in scrutinizing a statute like that and saying, look, you can't do that. We might want to do that, but you can't do that. Now, I will point out immediately, I don't believe corporations have constitutional rights. I have no problem at all pounding the crap out of corporations. I'm extremely sensitive about not imposing on individual citizens, not restricting the rights of individual citizens. We do get into some of those. For example, corporations that build and sell automobiles can be prohibited from building and selling fossil fuel automobiles in the state of California as of a particular point in time. And we can mandate that citizens stop driving fossil fuel cars at a particular point in time because of what it's doing to the environment. But at the same time, we have to empower and mandate that the state government officials or federal government officials who are ever imposing the limitation on them not driving fossil fuel cars have to give them subsidies to purchase electric cars so that they aren't fossil fuel. You can't impose the burden on a private citizen and not give them the means by which to procure the electric vehicles. In the same way that they can give $3 billion now to small businesses, they can give money to every citizen in the country to purchase a car. Or how about this? They establish a government-owned factory that builds the electric cars and gives them to the people. All of these things are possible for us to do here, but we have to remain ever vigilant to not violate private citizens' fundamental constitutionally guaranteed rights. And that I think that there's all kinds of good arguments that can be made that in light of the panic that sort of seized everybody in the face of this pandemic, that various government institutions got real careless about what it is that they were doing, so that we have a right as private citizens not to be subjected to things that we don't want to do with our body. And so that this issue is going to come up about the vaccinations. I can tell you that, perfectly well, when they come up with this vaccine, they're going to come up with all kinds of rules and regulations about how your kids can't go to school unless they've been to get this vaccine. You can't go to work without getting this vaccine. You can't appear in public places. They're going to give you little cards to show that you've gotten the vaccination. You might not be able to go to a movie theater because you'll be sitting too close to other people. There's all kinds of problems that we need to try to head off here. So that what I'm saying is we have a juridical mode of reasoning that is available to us under the strict scrutiny test, expanded as I have beyond the limitations of just the equal protection context. But we have the strict scrutiny vehicle to analyze all these. And so all of the people that are big proponents of the different type of conspiracies, and as you all know, I've prosecuted more successful conspiracy cases than almost anybody in the country, I think. That when we prosecute someone for engaging in a conspiracy, you can be pretty damn sure they're engaged in a conspiracy and that we're going to catch them on this thing. What I'm saying is I'm sympathetic to the people that are suspicious that there's some kind of a conspiracy going on here. I am not convinced that there is yet. I'm not to the point where I'm motivated to represent any of these people right now and bring a litigation accusing, for example, the Rockefeller Foundation of planning to get everybody inoculated and vaccinated so they can put some secret little tracers in them so that they can know where everybody is all the time. I'm not convinced that that's true. But I distrust to the highest degree government agencies, and I distrust major corporations, big pharma especially, oil corporations absolutely, banks for sure. There's all kinds of these centers of major power in our system that need to be challenged. They need to be challenged inherently. Okay, so what I'm saying is, I want you to become familiar with this strict scrutiny test. The first test, is there a compelling or legitimate government interest that motivated the actual promulgation of the rule? Does it infringe upon any of our fundamentally guaranteed rights? Thirdly, is it narrowly crafted to the most narrow possible and limited imposition on our constitutional rights in order to effectuate a compelling government interest? And fourthly, is there any evidence at all of there being some ulterior motive in promulgating the statute, even if they're publicly professing that there is some legitimate government interest or compelling government interest that might even be able to survive a facial test, of step one. That step number 4 is the big one that we need to take a look at. And so that I want you to be well armed by your familiarity with this 4-step test of the strict scrutiny test. And so whenever any of your friends come to you and say, let's have a debate about my suspicion that a certain thing is going on, and you say, good, let's haul out our strict scrutiny test. Let's put you to your test under step 4. What's the evidence you got of this ulterior motive? Let's listen to it and let's evaluate this. But don't shut them off. Don't close them off from Google or Facebook or Twitter. Don't get caught doing that. Don't get caught championing that, because I can tell you, whatever tools you allow to be put into the hands of the government or impose upon Google and Facebook and the others are going to be used against us. They're going to be used against us who are traditionally in the progressive community, because the reactionary forces get control of the institutions and they use those tools against us. Remember, the House Un-American Activities Committee started out looking for fascists. They were created in the legitimate government interest in promulgating such an Un-American Activities Committee was to hunt down fascists and sympathizers with the Third Reich. And they spent 99.9% of all their time and energy hunting down people who believed in progressive and socialist beliefs, the entire thing. And then after liberals, and then eventually after anybody who read more than 2 books a year. So you can't allow them to have these tools. So don't do this right now, okay? So don't get into condemning or trying to silence the people who are raising some of these fundamental questions. Just give them a mechanism by means of which we can rationally approach these questions and listen to them and debate this stuff and take our time and not castigate them just because they're right-wingers or left-wingers or libertarians or something like that. Because one of the things we need to learn from this period that we're going through is that we're all in these things together. And we've got to try to overcome some of these dialectical, confrontational, dehumanizing attacks that people are lodging against each other along the political spectrum. Okay? So that's my point here. That's why we have to protect the Constitution in the time of the coronavirus.
Okay.
There we are.
Thank you, Danny. Fantastic. I learned a lot there.
Super fantastic.
Well, thank you so much, Danny, for being with us tonight. Thank you for your time. It was really informational, and we will have you back on in 2 weeks.
We're so grateful that everyone is here to build your awareness, to have a sense of community here and in what is so important. And we would love for you to invite friends to widen their awareness and to build a community of wise ones with the ability to think things through and come from the heart and really make conscious change here.